We're live. Hear
Thank you.
ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, counselors. Let me begin by introducing the panel to you today. I'm joined by Justice Jeffrey Kinder and Justice Suk-Young Shin. My name is Justice Vuono. I want to thank you for presenting your arguments today via Zoom. As you likely already know, the rules of appellate procedure that govern oral arguments in the courtroom apply equally to arguments conducted remotely. Thus, each side has 15 minutes to present their argument, and there is no rebuttal. During the course of the arguments, we may experience some technical difficulties. We hope not, but if so, we ask for your patience, and you can be assured that if you have issues, we'll be patient with you as well. With that said, I'm going to call the first case on the list. As you know, you're here to argue the case of Commonwealth versus Gregory Saunders II, 2019-1753. Attorney Silvera.
May it please the court, Stacey Silvera for the defendant, Gregory Saunders. Your Honors, normally the court is aware of all the facts. I would just like to briefly start out with the issue in this case, which is whether the witness who testified, the complainant's mother, as it was allowed in as a spontaneous utterance as opposed to a first complaint. I'd first like to address the issue of the spontaneous utterance and the fact that the complainant was no longer under the sway of the startling event by the time that she spoke to her mother. Can
I interrupt you for a second? I'm sorry. I just want to be sure about one procedural point. At trial, the objection to the victim's mother's testifying was that this was really backdoor first complaint testimony, correct? Okay. Was there an objection at trial as to whether or not the testimony qualified under the spontaneous utterance exception to the hearsay rule?
The objection was, as I believe, as you framed it, Your Honor, it was to this as a backdoor attempt through the spontaneous utterance. I don't believe trial counsel objected specifically on the grounds that regarding temporal proximity and that the declarant was no longer under the sway of the startling event. But that is the first argument on appeal. And this is a case where, when looking at the excited utterance, the courts look at the location, temporal proximity, the age, the spontaneity, and the degree of excitement of the declarant. Here, the complainant had made numerous conversations prior to this conversation with her mother, which meant she was no longer under the sway of the startling event. First, after the incident in the home, the declarant ran out, and not noted in my brief, but in the transcripts that I came across when I was reviewing for the case. Actually, the first time the complainant's son testified that the first person she spoke to coming out of the house she briefly spoke to his father. There were two adult males in the driveway. Next, the complainant went to her car. Her son, the defendant, was pulled out by the two adult males. The complainant then got back out, locked the house, went back in her car, and then engaged in a 30-minute car ride from Saugus to Dorchester. During that time, she spoke to her son, LJ. At the first trial, which resulted in a mistrial, the court, Justice Lowy, determined that LJ would have been the first complaint witness, not the mother. In fact, LJ testified.
Let me ask you this, if I may interrupt you again for a second, and that is, given the facts, if you just described them, and yes, there was a significant amount of time between the event and the time that the victim spoke with her mother. But the judge made findings, and the judge determined that she was still under the influence of the event. And we look at that for abusive discretion, right?
Correct.
Okay. So his findings were fairly complete. In fact, he didn't even think he needed to hold a second voir dire because he recalled the events and the testimony from the first trial. So can you point us to where you think the judge actually abused his discretion in determining that this did qualify as a spontaneous utterance?
Yes, Your Honor, this is a question of how many times a victim can speak to people in a way. Prior to this, she might have still been under the upset, extremely upset by this incident. But by the time she makes this declaration, she's already engaged in reflective thought. She has spoken, and maybe to her son, what she said in the car that she was raped was a spontaneous utterance. That's not before the court right now. But then she made a decision to call her mother. She made a reflective decision not to tell her mother that.
Well, could you have more than one spontaneous utterance? In other words, would the judge have been within his discretion to determine that all of these statements were the victim was still under the influence of this rather violent incident, and therefore everything that she said was could qualify?
In this case, based on these facts, Your Honor, there were so many intervening events between the time that she left the house. If she spoke to the father in the driveway, she spoke to her son in the car and made a spontaneous utterance, said she was raped, called her mother, decided not to say she was raped, but did tell her about the incident, and then waited, got to the mother's house, waited. The mother took her children upstairs, and at some point, she made the determination to tell the mother that she was raped. This is the case where I believe that it was an abuse of discretion to call that conversation a spontaneous utterance, or to determine it was a spontaneous utterance, because by the time the complainant spoke to her mother, she had already made numerous statements. When in the course of when this court looks at cases, this is an interesting case, because this case, there were numerous intervening events. How many times can the complainant make a spontaneous utterance that it's still reasonable for the judge to determine within his discretion that the fourth spontaneous utterance, the fourth conversation after she's engaged in reflective thought, is still a spontaneous utterance? I briefly said it.
Can you talk a little bit about I'm sorry, go ahead, Justice Kinder, go ahead.
Well, I just wondered, do you agree as a general proposition that an excited or an emotional response to an event can be delayed for various reasons?
Yes, Your Honor, I do. I believe that's the case with children. Often, that's what the cases say with children. They often delay. This is a case, though, that the victim was an adult. She engaged in driving 30 minutes before she got to the place. I'm not saying that 30 minutes in general is too long of a time. What I'm saying is, on the facts of this particular case, this victim made numerous spontaneous utterances, and in the context of our case law, we don't have any cases on point that say you can only make 3 spontaneous utterances. You can make 5, but when does it end? How many times is she allowed to speak to people prior to making the disclosure to her mother? In this case, it would have been 4. And at a certain point, as an adult, she had left the location where the incident occurred. She was no longer in fear of the defendant coming after her. In fact, 2 adult males had taken him out of the house, pushed him to the ground, and in fact, her teenage son had kicked him. So she had then left the premises. I believe that people, I do believe that, Justice Kinder, that there can be a delay. In this case, I think the issue goes down to whether it was an abuse of discretion to determine that it was still a spontaneous utterance in terms of reflective thought that long into the process with so many intervening events. And I would just point on this note, you to a decision that's not actually Massachusetts decision, but I cited it, a 7th Circuit decision with Justice Ponsner's concurrence. But both in the majority and his concurrence, they say old and new studies agree that less than 1 second is required to fabricate a lie. This is not a very clear-cut area of the law in terms of how much time, and in this particular case, based on the facts, the defendant argues that the judge abused his discretion in determining that that was still a spontaneous utterance after all these intervening events.
Counselor, let me ask you this then. Let's say hypothetically that we agree with you, that there was an abuse of discretion. Then we have to look at prejudicial error. And in this case, there was no other first complaint testimony that came in. And the Commonwealth had a choice here to either, the only first complaint testimony available to them was that of the son, correct? So they decided to forego that and introduce the mother's testimony under a different theory. But Had they not done so, I mean, they could have introduced some first complaint testimony, at least one complaint. So how prejudiced was the defendant by the fact that it was the mother's first complaint? It's a two-part question, so hold on a second. It was the mother's complaint that went in instead of the son's. That's number one. And number two is additional complaint evidence came in through the defendant. He actually, in his own defense, presented testimony of further complaint testimony. So the Commonwealth cannot be faulted for multiple complaint testimony here. In the end, there was just one. So how is your client prejudiced by that?
Well, Your Honor, my client was prejudiced by first who the complaining witness was. I mean, the Commonwealth's not allowed to substitute complaint witnesses for a more detailed complaint. It came in.
Was this detailed? How was the detail? All she said was, he raped me, right?
But this is in the nature of first complaint, and had it been considered under Commonwealth versus King, it's possible that the other details surrounding those, what the mother asked her, a first complaint witness is allowed to testify to the details surrounding the complaint that was made to her.
Well, I do acknowledge if it was first complaint, it would have only been introduced to corroborate testimony. It would not have been introduced as for its full probative value. There is that.
It denied the defendant the chance to introduce another who was prejudiced had the first complaint evidence come in through LJ, the son. The Commonwealth says that he was a better witness based on what Justice Lowy said below. The defense argues he wasn't. I mean, the victim testified. She did not testify at the first trial that she recalled making the complaint to LJ. If a victim doesn't recall making a complaint, it doesn't mean it's not admissible. That's fodder for cross-examination. It goes to the credibility.
Mm-hmm.
And the defendant was denied that opportunity because the Commonwealth did not introduce that. The Commonwealth may have thought that the son conflated evidence, but that's not what Justice Lowy determined when he declared a mistrial. So it was highly prejudicial. Moreover, she was the person that testified was unlike contrary to what the Commonwealth stated in its brief, was a second grade teacher, a more credible witness than a 16-year-old kid, a 16-year-old son who watched this at the time. It was an attempt to backdoor first complaint evidence through the spontaneous utterance exception to the hearsay rule. It came in for a higher standard, as you stated, and in that regard, it was highly prejudicial, and the prejudicial value outweighed any probative value in terms of giving a fair explanation of the Commonwealth's case. The Commonwealth did not need to put this in as spontaneous utterance exceptions. The Commonwealth chose to, but the Commonwealth's case was not overwhelming with regard to the rape. The victim did not have a rape kit done. The complainant left the hospital after speaking to a detective, knowing he was coming to the hospital. The complainant never returned any phone calls, so the police were never able to investigate the scene of the alleged rape. And and as defense counsel brought out, there was no testimony from the son that the victim was screaming during this. Well, that may or may not have cut in the defendant's favor. And in terms of demeanor evidence, there were just no limiting instructions. So if this came in as demeanor evidence, which is admitted not to prove guilt, but to, as it bears on the victim's credibility, it seems overly prejudicial to the defendant's case. This is a case where it's exactly what the court in Commonwealth versus King stated shouldn't happen with the first complaint. Testimony from the victim that she was raped came in as substantive evidence of the crime.
I can envision, counsel, I can envision a lot of circumstances where first complaint might also qualify as an excited or spontaneous utterance. Is there any authority that limits the theory under which the Commonwealth can propose the admission of such evidence? In other words, does the Commonwealth have to pick one or the other?
I don't have a case for Your Honor that specifically states the Commonwealth has to pick one or the other. However, Commonwealth versus King suggests that this is the nature of this complaint was clearly first complaint of a sexual assault. She was raped. It's exactly what is first complaint evidence. So to determine that it comes in for its evidentiary value when the Commonwealth is picking and choosing amongst witnesses is exactly what the court was alluding to in King, and I think trying to prohibit. I would just follow up that I would, suggest this court is similar to Commonwealth versus McGee, where the first complaint was a neighbor and not a police officer in that case, and the Commonwealth was not allowed to substitute the first complaint witness for the police officer who came because the complainant simply said I was raped to her neighbor, and then called the police. Commonwealth tried to introduce the police testimony, who arrived immediately and had far more detailed testimony. And the court said that the neighbor was the first complaint. And this case is very similar to that. If there are no further questions, I would rest in my brief.
All right, I'll check with the panel. I don't see that either of us, anyone has any further questions. Thank you very much. I'm going to make one comment. I did notice that Justice Lowy made a big emphasized that we need to call the rape, no longer call it a rape kit, but a collection evidence kit. And it's hard to remember that for those of us who have been, I'll speak for myself, I've been around for a long time, but we should try, okay?
I apologize, Your Honor.
Oh, no apology necessary. But I just wanted to point that out. So let me turn now to the Assistant District Attorney, Counselor Leary. Please go ahead.
Good morning. May it please the court, Catherine Leary on behalf of the Commonwealth. The Commonwealth requests that the court affirm the defendant's convictions for the sexual and physical assault of the victim. What this case really boils down to is the principle that the Commonwealth is entitled to put on its case as it sees fit within the rules of evidence and criminal procedure. Commonwealth is not required to put on first complaint evidence in a sexual assault case. And here it chose not to put on first complaint evidence and rather admit an excited utterance. And Justice Lowy did not abuse his discretion in determining that the victim's statements to her mother were an excited utterance and that she was still under the excitement of the startling event and that the statement was not a product of reflective thought. In support of this, apart from the rape, which is a well-recognized startling event under the case law, the victim immediately after the rape left her house, grabbed her keys, grabbed her kids, within a half an hour got to her mother's house. And during this car ride, well, let me start first. When she comes out of the house, she's screaming, she's crying. That's how she describes it. That's how her son describes it. In the car, she says she is attempting to keep a straight face, crying. Her son says the victim was rattled, scared, hard for her to talk. On the phone to her mom to let her know that, hey, we're coming, it's 3 a.m. The mother describes her, she couldn't understand what she was saying, a lot of deep breathing, huffing and puffing. And then when she gets to the house, she's described as sitting on the couch and falling apart and sobbing until she's able to say what happened. And
actually, Counselor, that's the point where I was wondering if you could comment. It seems to me that the victim here is able to recount what happens to her at a point when she is calmed down, at a point when she has stopped for a moment and can actually be reflective and tell her mother what's going on. Doesn't that just fly in the face of what you need to find for the spontaneous utterance rule to apply?
I would disagree. And if you look at the mother's testimony, when she sits down on the couch, it's second trial, volume 3, starting at page 152, 153, and 154. As she's able to compose herself enough to make form words. It's described as the conversation's choppy. That's at page 154. Not totally clear. The victim's mother says it's not totally clear what she was saying because she was crying. And she would say a little bit. She'd say a few words and start crying again, and then say a few words and start crying again. So I don't think under those circumstances, it was an abuse of discretion for Justice Lowy to find that she was still not able to have a reflective thought besides just saying what had happened. This is not a case such as in McCoy, where the victim is talking to a sane nurse in a question answer format for 3 to 5 hours. This is her within an hour of this vicious physical and sexual assault, just trying to get out what happened. And I think Justice Vuono, you had said this or asked this question to my sister, in that the fact that she was able to call her mother, or say, say we're going to your grandmother's house to her son. Those are all spontaneous utterances, all within the span of an hour. And I don't think there's a limitation of how many spontaneous utterances you can make. I think the question is whether each statement is a product of reflective thought. And I think here on the facts, Justice Lilly was well within his discretion in finding that the final statement at issue here to the victim's mother was not a product of reflective fact, that she was still under the influence of the startling event.
Ms. Lilly, let me ask you the flip side of the question that I asked Ms. Silvera, and that is, do you believe the Commonwealth is always entitled to pick and choose whether it offers evidence under the first complaint doctrine, or, assuming it applies, the excited utterance doctrine?
I do think the Commonwealth is entitled to put on its case as it sees fit, and is entitled to not put on first complaint evidence if it so chooses. I will point the court to unpublished opinion, which is cited in my brief, Commonwealth v. Glenn, 74 Mass App Court 1123. It's a 2009 case. It's in my addendum. And there, the court said, no first complaint witness testified at this trial. The victim's statements to her father directly after the assault were admitted as an excited utterance, and thus the first complaint jury instruction was neither given nor required. Now, that's not quite the holding, that's the facts, but I think it's an endorsement of the principle that the Commonwealth, so long as it's within the rules of evidence, is allowed to put in its case as it sees fit. Now, if the son had testified, first of all, I think it would have been qualified as a spontaneous utterance, but even if it had been first complaint, perhaps this would have been a closer question as to whether the mother's statement should have come in addition, but that's not what we have here. And I think the Commonwealth was well within its right to present its case.
What would make it a closer question?
I think what would make it a closer question is there's case law, even though I would argue, or the Commonwealth would argue, that the son's statement wouldn't be a first complaint, it would be admissible as a spontaneous utterance. But then you get to the question of multiple complaints, and is it independently admissible or relevant above and beyond that other complaint evidence that it's in the form of a spontaneous utterance. But here, so I think if that had happened, it might be a different argument. I still think that Justice Lilly would have been well within his discretion to admit both statements, but that's not what happened here. As Justice Vuono had pointed out, this was the only complaint evidence. It wasn't detailed. The son's testimony at the voir dire was, she had said he raped me. That's the same as what she said to the mother. I think here, even if the court were to say that Justice Lilly abused his discretion, which the Commonwealth is not conceding, there was no undue prejudice in this complaint evidence in the form of spontaneous utterance.
Well, the Commonwealth was able to present evidence in a more forceful manner, in a way that could be considered by the jury for its full probative value, rather than just as corroborative. And it seems to me, at least we can say this, and let's assume that you're absolutely correct, that the Commonwealth can pick and choose its evidence and put on its best case, as long as it's doing so within the rules of criminal procedure and follows the case law. But clearly here the Commonwealth chose, they prefer to have the mother's testimony rather than LJ's, right? Rather than the son's. That was a strategic choice that the Commonwealth made.
It did, but I also think this is not a case where if the son's testimony as a complaint had come in, that would not, and as Justice Lilly noted, it wouldn't have just been first complaint for a corroborative value. That would have come in for its full substantive value. And also, I would point out, the Commonwealth, for whatever reason, I wasn't the trial prosecutor, decided to put on the mother instead of the son. But this also benefited the defendant greatly, because his whole closing argument was, look at the son. He's the person who you should look at for credibility. He was there. And so I think that argument wouldn't have been able to have been made, or been less forceful, if the Commonwealth had sought to admit the son as the first, not even as the first complaint, but have his complaint come in as spontaneous utterance. So on that fact, I just hear there's just not, in the Commonwealth's view, a lot of undue prejudice from the mother complaint testimony coming in as spontaneous utterance, properly admissible as a spontaneous utterance. There wasn't a piling on of first complaints or complaint evidence, which is the concern under King when we switch from fresh complaint to first complaint. And I would also note, yes, it's hard to have a lot of corroborative value as to the sexual assault, but I do think this is a case where there was corroboration to the victim's account of events, which would include the sexual assault and the fact that when the son came in, he said he found the defendant on top of the victim with her shirt down. That's consistent, lines up directly with the victim's testimony, as well as, although this goes to the physical assault, the injuries that she had in the pictures were consistent with those injuries. That even though that goes to the physical assault, it is also corroborative of just the victim's account of events, and that the sexual assault also happened. So I think in that whole totality of circumstances of this case, there was no abuse of discretion. But even if the court were to find error, it does not require reversal in this case. If the court has no further questions, I'm happy to rest on my brief.
All right, I'll just check with the panel. I see none from Justice Kinder and none from Justice Shin. So I want to thank you both very much for your arguments. They were both very helpful. We'll take the case under advisement and get back to you as soon as possible. And meanwhile, we hope that you and your families stay healthy and well during this. Okay, looks like we're now streaming live. So I'm going to go ahead and begin and just say good morning to you. Introduce the panel to you as well. I'm joined today by Justice Jeffrey Kinder and Justice Suk-Young Shin. My name is Justice Vuono. I wanted to thank you for participating today via Zoom and remind you about something you likely already know, which is that the appellate rules for oral argument apply equally to cases argued on this remote platform as they do as if you were in the courtroom. So each side has 15 minutes and there is no rebuttal. During the course of your arguments, we may experience some technical difficulties, and if so, we ask for your patience, and we will be patient with you as well if that happens. Now I'm going to hold on for a moment because I don't see I'll call the case, and then after the timer will come up afterwards. So the next case is Commonwealth versus Cordell Scott, 2019-1506, and we're going to start by hearing arguments from Attorney Arter.
Thank you. Good morning, Your Honors. My name is Corey Arter, and I represent Mr. Cordell Scott in this matter. Very briefly, just by way of background, this is a fairly simple case. Involves a routine motor vehicle stop, a speeding ticket on July 2nd of 2017. Mr. Scott was pulled over by a Trooper Morales. At the scene, he was cited for speeding and for operating after suspension on an OUI. At trial, he was charged the same. At the trial, the only person who testified was Trooper Morales. And the primary issue in this case, although I'll outline the three main issues raised on appeal, is identification of Mr. Scott. Mr. Scott has raised three main issues on appeal. I'll outline them, then I'm going to circle back to the one which I think is the most important, or perhaps the dispositive one. First and foremost, he raised the issue that the RMV records were not properly certified or attested to, and that all of the pages contained therein were not certified or attested to. Second,
Excuse
even
me,
assuming—
Before you leave that, just so I can clarify a procedural point, of course, we don't have the original exhibits here. Let me just ask you, is there any question about whether or not the RMV packet and its attestation, I understand your argument that the signature was not original, but is there any question about the rubber stamp being original?
No, and I'm not, my argument is not so much focused on the rubber stamp per se. I understand that courts admit the records with the stamp. My issue is that it doesn't attest to the document, and there are two separate packets that were introduced. The packets that all of the pages contained therein are true and accurate copy, and that doesn't indicate how many pages were attached. And I understand that there was some redaction done and some of the pages were taken out, but there's no indication on the face page by the Registry of Motor Vehicles that it has attached a certain number of pages and that those pages are all true and accurate copies of records kept in the ordinary course of business. Notwithstanding that, there's a second packet that's introduced that also similarly has a stamp on the side. But those actually have a disclaimer. Those are the computer printout type of RMV records, have a disclaimer on the bottom that said, these are not records that are all inclusive or indicative of biographical data. And there's a disclaimer at the bottom of the records. You can see it on the records themselves. Notwithstanding that, even if we were to assume that they were properly admitted with the rubber stamp and not an indication of the page numbers. The main issue in this case is that there wasn't sufficient evidence presented at trial in the Commonwealth's case that Mr. Scott knew his license was suspended. Now, they introduced these records, but the only person who testified at trial was Trooper Morales. I would suggest that there were three things. I'll circle back to the first, that there wasn't enough evidence connecting Mr. Scott to the records. Further, the records themselves, the ones that were introduced, did not say that he was mailed notice his license had actually been suspended. The notice that was produced.
Can I stop you
Sure,
again for
absolutely.
a second? A question regarding your first comment that there wasn't sufficient evidence connecting the defendant to the records. The Commonwealth points out in their brief that these records contained not only name, date of birth, address, but also a photograph and physical description, which I assume the jurors would have been able to compare to the defendant in the courtroom. Why doesn't that, or why isn't that enough in this case?
And again, that goes to the sort of two sets of records. I would suggest Trooper Morales testifies on the stand. He pulls him over, doesn't even recall if he got any identifying information from him at the stop itself. He wasn't arrested, he wasn't booked, there was not a police report, there was nothing wherein his identity, his date of birth were verified. Commonwealth did not introduce the citation into evidence. On cross-examination, the trooper concedes that he scribbled out some things and then wrote some different address. The address he wrote on the citation doesn't match any of the addresses listed in these documents that they did produce. He didn't know his date of birth. That was not introduced as part of the Commonwealth's case in chief, which I think would be the primary identifying information, because not only did they introduce RMV records, which go by the date of birth, but they also introduced a 2013 docket sheet, which again, under Cueva and Oliwoli, and I always mispronounce that, I apologize. The cases clearly say identity of name alone is not enough. And the second packet of documents that counsel references with the photograph, there's a grainy photograph, and again, admittedly, we don't have the original, of somebody who resembles him. I would suggest that even the cases that go as far as saying, okay, trooper testifies to name and date of birth without more connecting him to the records, I would say that's still insufficient.
How about the fact that he was 6 feet 6 inches tall?
I don't know that any physical description was ever given, and I don't know at court, other than the trooper saying, yeah, that's the person that was in the car.
Well, it was on the documents, right? Excuse me, the defendant's height was part of the information that was on the same page as his photograph, correct?
I believe the copy of the license, the grainy license, had a photograph and a height. My concern with this, and my concern in the issue that we raised, is that if you go by the case law, and even the most recent, well, I understand is persuasive only, Ravenscraft, says it's not enough for somebody to get up and say, okay, this is Cordell Scott, therefore I'm connecting him to this. At the time he's arrested, the trooper doesn't even know how it is they came up with any information, doesn't recall if he gave him a license, doesn't recall ever asking him for background or biographical information, but yet says on the stand, and this is the sort of third broader issue raised, I learned at the scene that his license had been suspended. And I would suggest to you that that was inadmissible hearsay and should not have been admitted by the judge. There's a case directly on point on that with regard to Commonwealth versus Royal, that where the officer got up and said on the stand, oh, you know, at the scene, I ran the name through the database and it came back as suspended, that was considered hearsay.
Let's assume that in fact the officer's testimony was hearsay. If we conclude that the records were properly before the jury, wouldn't the officer's testimony have been cumulative of that other evidence?
Well, again, even if the records were properly admitted, my argument is there's not enough to connect Mr. Scott to those records. Therefore, the other evidence is not overwhelming. They used that statement, and they attempted to use the 2013 docket to bolster the deficiencies in the connection of the prior records. And my suggestion is that there's not enough connection to the 2013 docket, again, because we don't have date of birth, we just have name. An identity of name is not enough. So similarly, if you have a question as to whether or not there's a connection, and the only additional evidence would be his testimony on the stand, again, doesn't say date of birth, doesn't give current address that matches any of the records, doesn't give biographical data, does not give date of birth, then that statement becomes important, because I would suggest that that statement's being offered to essentially prove the element of the crime, the main element. This is only one element here, whether he knew he was driving without a license. So I would suggest that that statement is hearsay, and it was prejudicial because it was used to support the deficiency in the other records, or the lack of connection.
What do you do about the closing argument? It does seem like in the closing argument, counsel more or less conceded that the defendant's license was in fact suspended and that he is the person named in those records. So what do you do with that?
Well, I guess that I would go back to at the point that the trial court erred in failing to enter a required finding of not guilty. So before we get to that point, that the error occurs at the close of the Commonwealth's case, if they have not introduced sufficient evidence to connect Mr. Scott to these records, that they have failed to prove their case. And at that point is where the error occurs. And that the trial court erred in failing to enter a required finding of not guilty at that point. So with regard to that, again, my main argument, and what I think is the most important, is the lack of connection. If there is a lack of connection, and with regard to, and I hadn't addressed the docket sheet per se, my argument is the same with regard to the RMV records as it would be with the docket sheet, that there was not enough connecting him to those records. And it's also not enough for the Commonwealth to have relied upon normal practice, that in that court, it was communicated to him that his license was going to be suspended. So again,
But
without an
Minister,
adequate.
there was a receipt that from the United States Postal Service that notification had been sent, correct? Wasn't that part of the packet?
There was a letter that it was sent to this other address, and again,
Correct. Yeah.
Trooper doesn't say that's his address. Trooper doesn't. That's
No,
their
but
case.
but there was that receipt that was in there, and that, for example, distinguishes this case to some extent from Cuerva, where that did not happen.
Sure. Yeah, absolutely. But unlike Cueva, in this case, the receipt is for a letter notifying him of a hearing. And again, similar to the cases that talk about you can't rely upon normal practice, the only thing that we know is that a letter was sent to an address which has not been identified as his address, to a person who has not been connected to a date of birth, saying that at some point there's going to be hearing as to whether or not his license should be suspended. There was not a subsequent letter to him in my reading of the records that in fact this hearing has passed and his license is being suspended. So in addition to—
I'm looking at that notice right now, and it says, this is the only notice you will receive. This revocation will go into effect at 12:01 a.m. on 1/3/2015. It does go on to say that he was entitled to a hearing.
Yes.
But that sounds like pretty clear notice to me that if he's driving after that date, he's driving under revocation.
Sure. I guess my issue with that is, Your Honor, is that there's no indication in the record beyond that letter that his license had been suspended after that date. So if you follow the logic in the cases that say, you can't just follow the normal course or the normal procedure, we don't know that a hearing took place. There was an additional documentation. There was nothing else that was mailed to him. There was certainly nothing mailed to him at the only address identified in court in the Commonwealth's case as his address, which is this 663 Columbia Road in Dorchester case. Address.
What do you mean if we don't know if there had been a hearing? There only would have been a hearing if your client had requested one. And
yes,
he would have known about it
was
had he
no
requested one.
Sure. And there was no evidence that it took place and that the suspension took place, is my argument on that point, that there wasn't a subsequent letter saying that it had suspended. I do understand that it says if you don't come to this hearing. My suggestion is there's nothing backing it up in the
No, I
registry.
think it actually says you may request a hearing, is it not?
Sure.
I don't have it up on my screen, but that's my recollection.
Yeah, and I could pull it up, and I'm sorry, I don't want to bounce out of the Zoom.
That's all right. That's okay. We'll look at it.
I'm more worried about the technology at this point. I know you have it in front of you.
If you accept that this is a true copy of the defendant's driving history, and in fact, he did request a hearing and one occurred and the suspension was overturned, wouldn't the fact finder be able to presume that would be in the records, the RMV records?
Yes, and my reading of them, and I know that you have them in front of you. You can read them. I'm slightly concerned. I decided to leave them up electronically about bouncing out. But my record is the only evidence of it is that noticing we're going to have this hearing.
Right, but it says your license is suspended. You can request a hearing. Yeah. Had a hearing occurred, can't you presume that it would actually be reflected in the RMV driving history?
And I guess my argument to that would be that it's no different than the arguments that go to, can you presume that somebody was notified in writing? Can you presume that the normal course would be to put it in there if there had been? That we can't rely upon what normally occurs, but that what's contained in the record. And I don't see anything one way or the other that after that date of that letter, there's a notation that it was suspended. The only thing in there that there's evidence of is the letter itself.
Okay.
Okay.
All right.
Further. Thank you.
I'm going to see if there's any further questions. I don't believe so. Anything that I don't want to cut you off in the last 20 seconds, but is there anything else you want to tell us?
No, I think I'm good. Thank you. I'll rely upon my brief for the reminder.
Okay. Thank you very much. I'll return to the Commonwealth now. Attorney Sherman.
Good morning, and may it please the court, Catherine Sherman, on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. Beginning with the issue of whether or not the defendant was properly tied to the records, properly identified through the records and at trial. As the court mentioned in its questioning, the trooper who testified made an in-court identification of the defendant. That directly connected the man in court to the man identified in the Cordell Scott records through the photo present in the RMV photo and demographic information packet. The quality of the photograph that's in the record appendix is not indicative of the quality of the photo that was presented at trial when I reviewed the exhibits with the prosecutor. And should the court want, I would be happy to file a motion to transmit the original exhibits so the quality of the photo can be reflected. The photo showed a face from which a jury could connect the records to the person in court. Through the exhibit on page 15 in the defendant's record exhibit, record appendix, there's the photograph, a license number, a date of birth, a name, and an address. And all of those interconnect with the other exhibits presented by the defendant that further bolster the identification of the defendant and his connection to these records. To touch on the issue of the address that's reflected on the page that has the photograph of the defendant is 349 Park Street. That's the address on the certified conviction admitted into evidence and into the notice of suspension mailed from the RMV. It is the burden of a driver to update the registry of motor vehicles should they change their mailing address. And that's Chapter 90, Section 26A. The burden on the registry of motor vehicles to notify a driver of their license suspension is just to mail the notice of suspension to the last known address. And that proper mailing, receipt of the mailing as entered into evidence through the Commonwealth suffices to prove notice of license suspension. And that I'd refer the court to the case that we've discussed before, Cueva, on page 787 of the Cueva case, that alone is sufficient evidence of notice. In this case, the Commonwealth.
Can I ask you a question about the trooper's testimony? I know I'm lurching forward a bit, but
sure.
it did seem to me that what the trooper testified to in this case, that is, after stopping him, I learned that his license had been suspended or revoked, was not materially different from what the trooper testified to in Royal, where the holding was fairly clear that that's inadmissible hearsay.
And the distinction that I would point out to you between this case and Royal is that in Royal, the Commonwealth presented no other evidence of license suspension. Footnote 7 of Royal specifically says that the Commonwealth presented into evidence notices that the registry intended to suspend his license. And that's distinctly different than the evidence presented here that on a specific date and time, the defendant's license was suspended. The records in this case, in the defendant's case, are not ambiguous about whether or not his license was suspended by the Registry of Motor Vehicles.
Is that an argument that goes to the prejudice or the admissibility?
That would go to the prejudice were it found to be hearsay. Because as I believe you said, Justice Kinder, the evidence in this case was cumulative. The trooper's testimony that he learned the license was suspended was cumulative of the other direct non-hearsay evidence presented by the Commonwealth. The statement that the trooper gave was directly scripted by the judge in this case. In the extensive motion in limine, he gave the direct words that the trooper testified to. And the reason the trial judge scripted it so is that he believed the jury needed to hear how this defendant got from getting a speeding ticket on the side of the road to being in court on trial to connect those dots. And of course, the jury wasn't hearing about the OUI or the other facts of the case. And reading between the lines, I think the judge was reasoning that the statement of the trooper was not being admitted for the truth of the matter asserted. Should this court find it to be hearsay, I would argue that it's not prejudicial and that Royal supports the argument that it's not prejudicial because it was cumulative of the other direct evidence.
Is our standard prejudicial error?
No, it would not be prejudicial error. It would be, I apologize for not having this on the tip of my tongue. It is reviewing for prejudicial error, should you consider it inadmissible.
Prejudicial error. So your position is the error was preserved? Yes,
it was preserved. The defense counsel objected during motion in limine. I can't recall if he objected again at trial. But in this case,
well, he didn't object at trial, but your position is that the objection during the motion in limine hearing was sufficient to preserve the error.
That's correct. However, in this case, I think it's very clear to see that that statement was not prejudicial error because the jury did not take that statement to bearing on the verdict. The jury parsed the elements of the crime. And let me take one step back. The charge presented to the jury was operating with a suspended license for an alcohol-related offense. And the jury convicted the defendant of operating with a suspended license. The trooper testified that the defendant's license was suspended for operating based on an alcohol-related offense. The jury clearly did not take that statement to be to have full bearing on the verdict that it presented. It parsed the elements, it reviewed the elements of the crime, and it found the defendant guilty of a lesser included offense, which I think is a clear example of how the trooper's statement did not prejudice the defendant in the ultimate verdict.
I don't know. Go ahead. I'm sorry. I was just going to say that I don't know if the panel has any further questions. I'm going to see. And if not, I don't want to take away your time. But if you have anything else to say, we'll consider it. And otherwise, we'll consider all of your arguments that were presented in the briefs and have already been presented today.
Thank you. I would briefly add one more comment to the argument about the trooper's testimony. And in this case, he was not commenting on the ultimate or the ultimate issue before the jury, because there are elements of operating with a suspended license, notably that the defendant had notice of that suspension. That was not part of the trooper's hearsay statement, should the court find it to be hearsay. It's distinguished from a comment on the ultimate issue in that way. But otherwise, I will rest on my brief. Thank you.
All right. Okay. I'm going to check again with the panel to make sure there's no further questions. I see none. I'm going to thank you both very much for your arguments today. And we'll take the case under advisement, get back to you as soon as we can. And meanwhile, we hope that you and your family stay safe and healthy during this time of this health crisis. Okay.
We are live.
Thank you. Good morning. Let me begin by introducing the panel to you. I'm joined this morning with Justice Jeffrey Kinder, Justice Suk-Young Shin, and my name is Ariane Vuono. I want to thank you for presenting arguments today via Zoom. It's incredible that technology allows us to all be together for this argument from Maine to Western Massachusetts. As you likely know, that the rules of appellate procedure that apply to arguments in the courtroom apply equally to this remote format. You each have 15 minutes and there is no rebuttal. This is a complicated case. You can be assured that we've read everything that you've given to us, including a lengthy decision by the DPU. So we suggest that you get right to your most important arguments as soon as you can. During the course of the arguments, we may experience some difficulties of the technical sort. If so, we ask for your patience, and we can be assured we'll be patient with you as well. So this case is the Attorney General versus the Department of Public Utilities, 2019-1383. And Assistant Attorney General Tepper, you are the go first. Am I correct?
Correct.
Yep.
Good
Okay.
morning,
Please begin.
Rebecca. Thank you. Good morning, Rebecca Tepper for the Attorney General's Office. In this case, the Department of Public Utilities authorized the highest ROE that it has given any public utility commission since 2009. And it did so despite the fact that the witnesses, except for the company's witness, all the expert witnesses testified that 10%, the ROE that the department gave here, was too high and unreasonable and didn't fit in within the range of reasonableness. They also did so despite the fact that their findings, to the extent that they gave you a clue about what it was that they were thinking about, most of them seem to point towards a lower ROE rather than a higher ROE. This single decision by the department is costing customers $26 million a year, compared to what that would have been if the DPU adopted the Attorney General's more reasonable number of 8.8. This is a 5-year rate plan. So that means that customers are paying over $1 million more than they should. And this is a time when customers really are struggling to pay their bills. And it's just not right to have them have to put $100 million of their money into shareholders' pockets when it's not a reasonable ROE. So I know that you said, Justice, that this is a complicated case, but I think it's actually not.
Well, maybe let me tell you. Maybe it can be reduced down to the following. All right.
Sure.
Okay, go ahead. You tell me why you think it's not complicated, and then go ahead.
I think it's not complicated because
I think you're about to.
I'm sorry, I'm missing you.
No, I think that we were just talking over one another for a moment. And I think my last comment was, retort to your question, your assertion, this is not a complicated case. And I said, go ahead and tell us why not.
Okay, thank you. Because the SJC has outlined very specifically for the department what it needs to do in order to write an order that is consistent with 30A. And it's really just 4 things that they had to do that they failed to do here. First, they couldn't pick the number out of a hat. They have to weigh and balance the evidence. Merely summarizing the evidence or listing the factors that they consider also is not enough. They need to explain how they balance those factors. And if you notice, there's a couple of times in the order where the department says, we will consider in making our final decision, yet they never actually go back to it and tell you how that particular consideration impacted the decision of 10% one way or the other. It just kind of gets, you don't know. The second thing is that they have to make sufficient findings and provide a guide for their reasonings. Here, there just isn't adequate findings, and the roadmap really leads, the lack of a roadmap really leads the court left to speculating about how you can get rationally to a 10% number when all the witnesses, except for the company's witnesses, said it wasn't reasonable.
So let me just ask you a question
absolutely.
right there, and that is, there was, of course, testimony with respect to that amount, the 10% amount. Actually, the companies were asking for a slightly higher row. So when you say that the number was pulled out of the hat, can't we? Isn't it permissible for the DPU to exercise their own judgment, look at that evidence, and in this case, to have determined that it was the company's expert testimony that they gave more weight to than what the AG and the other interveners had suggested?
You know, what's interesting about that company testimony is if you look at it, it's on page, I think it's 583 of the record appendix, is there a chart of all of their findings, of the company's findings. And their DCF analysis, they ran 27 different runs, high, low, mean. And out of the 27, 2/3 of them were lower than 10. I mean, not even the company really had evidence that demonstrated that 10 was a reasonable number. The department has discretion here, but the reason why they need to provide information is precisely because they have discretion. They need to explain how they're using that discretion. And here they didn't.
I take it your argument is not that the department couldn't have set the ROE at 10, but that it didn't adequately explain why it did. Is that accurate?
Well, our position is that there really wasn't substantial evidence on the record to support 10, but that would be putting the cart before the horse here, because the department hasn't explained how it decided that there wasn't substantial evidence, or how it decided that 10% was reasonable.
There is
Assuming
one.
that go ahead.
Sorry, go ahead. Go ahead, Judge.
I was just going to ask, assuming for a moment that we agree with the proposition that the selection or the setting of an ROE is not subject to mathematical certainty and there is a component of subjective judgment involved, what exactly is it that we would be asking the department to do upon remand?
Well, it's interesting. You know, the department has in the past been provided more information so that you can follow how they got to their number. Even if you look at the Boston Edison case that the company relies on very heavily, if you look at the underlying case where the department issued its order, it was very clear on what it did. It looked at the parties, it first looked at the company's evidence, and they found that not credible, making lots of findings about problems with the company's evidence. Then they looked at the intervener's evidence and they said, we think the intervener's evidence is generally represents the market better, the conditions of the market better. And then they adopt the intervener's range of reasonableness. And what they end up doing in that case, which I think is really interesting, is they don't, they say that's the range of reasonableness, but they actually give a higher number. They award a higher number, and they explain at length why they're awarding a higher number slightly above what they had said was the range of reasonableness. So it's very clear what they did, and that's what they needed to do here. They needed to take us through their thought processes about how it was that they got there. How they got from A to B. Because what we're really left here with is a sort of a decision that doesn't make sense and a black box instead of a guide.
There is one area in which I think the department did provide a roadmap, and that's their discussion of the qualitative factors. Can't that part of the decision from pages 711 to 713 be read as a finding that a rate at the higher end of the range is appropriate here?
I assume you're talking about the discussion about their service quality.
The performance standards, right?
Yeah. So it's interesting. They talk about how the company provided good service over the course of the last couple of years, and it's the Attorney General's position that the company is required to provide good service. So you don't get icing on the cake if you provide good service. There have been cases where there has been very poor service where the department has lowered the ROE. But in this case, what they say is they're very clear. They say, we're not adjusting it one way or the other. We didn't find evidence to adjust it one way or the other. So it didn't play a role. To the extent that they provide us with any information, it doesn't appear to have played a role in moving the ROE to the higher end, lower end, any way at all.
Oh, I see. I didn't read that. I didn't read the decision that way. With appropriate deference, it seems to me a fair reading of it is that a number at the high end of the range is appropriate here because the company has met its performance standards. Whether you think that's proper or not, that's what the decision seems to say, and that there's no evidence of other shortcomings in other areas that would warrant the department from then adjusting that number downwards. Why isn't that a fair reading?
Well, I think if you look at the footnote in that area where they talk about, I think it's in a footnote, they make it pretty clear that they're not adjusting the number for service quality or for performance standards. I can look it up if you give me 1 minute.
I have it right here. Yeah, it's page 711. Footnote 373, I think, sorry for what you're talking about.
So if you look, I'm sorry, if you look on the page of the order 713, so it says the department finds no evidence of systematic service quality shortcomings in other areas of the company's operation to warrant an adjustment to Eversource's allowed ROE.
Right, it says shortcomings in other areas, but if you look at the page before that on page 712, it says the department may set ROEs that are at the higher end or lower end of the reasonable range based on above average or subpar management performance and customer service. And the department
they say they may, but they never really do.
Okay.
I'm not denying that the department says that they can do that, and they've certainly lowered it in other cases. But here, they never say, they say, yeah, they had good performance, but they don't say, because they had good performance, we're going to do it in the higher end of the range. They say, we're not going to adjust. But I understand your reading, but even with that, that is usually a 1/10 of a kind of thing that you would move. It would not be the sort of the breadth that you have here between other parties.
Accepting my reading of that part of the decision, your position is still that there isn't adequate reasoning.
Well, our position is that certainly that there isn't an explanation of how they get to 10. They're not providing the guide.
Just to be clear, you do agree that these the above average performance in customer service is a relevant factor and could be considered. I think that you said that it's just a small factor. I think you characterize it as something that's worth about 1/10 of the overall decision-making process. But it is still a valid fact.
The department says that they can do that. I cannot remember a case where they have done that. There are cases where they have adjusted it downward.
Okay. For poor performance.
For poor performance. in at least 2 cases, and I think they're cited in our brief.
Could I ask you an unrelated question?
Sure.
Why isn't Eversource a party to this appeal?
I don't know.
You don't, okay.
No,
Also, the same question. It seems very unusual to me that Eversource has not appeared in this appeal to defend the decision or not defend it one way or the other.
I think what they think is this case is, as I said earlier, not that complicated of a case, which is, did they make their explanation or did they not make their explanation? And I think that the way Eversource would see that would be, well, that's a department issue. This is about the way the department writes its orders, not about Eversource. That's what I would suspect.
So following up on that, and also on Justice Kinder's question earlier, should we agree with you and send this case back for a remand? Then what we're really asking for is for the DPU to go through an exercise of explaining, I believe, as you said, how they get from A to B. But much of the information that was relied upon by all the parties at the time had to do with predictive issues, where the market was going to go, what was going to happen. If we send this back on a remand, does the department just stay focused as to what happened in 2017 and not take into account or reopen the issue with respect to whether or not anyone was correct or incorrect on their predictive, on their all the elements of where they had to actually predict the future?
I think that the way that the department has done it in the past is they only make their decision on the record in the case.
Right. Okay. Like in any other situation. All right.
Yeah.
You only have less than a minute. Thank you for answering our questions. I'll see if the panel has any further issues that they would like to address with you. And seeing none, you still have 3 seconds. If there's anything you want to say, I don't want to take it away from you.
I guess I would just say that it's important for us to have the department explain its reasons. The court, we can't take a case to court if we don't know what they relied on. And you can't make a decision about whether it's substantial evidence or not if they don't tell you what they relied on. Thank you.
Thank you very much. All right. Turn now to Attorney Hewitt.
Good morning. May it please the court. William Hewitt, Special Assistant Attorney General, appearing on behalf of the Department of Public Utilities. Contrary to the Attorney General's argument, the department's order contains sufficient subsidiary findings to support its judgment that 10% is an appropriate ROE for Eversource. In listening to the Attorney General's argument this morning, it's noteworthy that they now raise belatedly an argument that there was not substantial evidence on the record. That was never an issue that was raised either in their notice of appeal or in their briefing, and that's an issue that's been waived. But even if they had pressed that issue, there is certainly more than substantial evidence on this record to uphold the department's order and its determination that 10% is the appropriate ROE. It's important to keep in mind that a public utilities authorized return is not an immutable number. It requires the department to apply its specialized expertise and judgment to establish a rate that will preserve a utility's financial integrity, allow it to attract capital on reasonable terms, and be comparable to returns on investments of similar risk. These are bedrock principles initially enunciated by the United States Supreme Court in Hope and Bluefield, and echoed by the SJC in cases that include Fitchburg Gas and Electric, 371 Mass at 884.
Councilman, may I ask you a question? It is true, however, here that the number that was chosen, the 10% for the ROE, was higher than had been suggested by all the other parties to this case, correct?
That's correct.
And slightly lower than what the companies had recommended. So can you tell me in so many words why that number was chosen? What are the exact reasons for someone who's not steeped in the language and the industry What are the reasons why that is the appropriate number?
Sure, Justice Vuono. Thank you for the question. And it's important to understand in this context, this is a litigated process that the department undertakes. There is typically one proponent or one petitioner, that's the utility, and then the Attorney General comes in as a ratepayer advocate, looking out for the interests solely of the ratepayer. And then there are typically a number of other interveners who are like-minded. So so when the Attorney General makes assertions or observes that there are several models that were performed by interveners in the case that came in lower than what the company recommended, given the litigated nature of these proceedings, it shouldn't surprise anyone that—
I think that she indicated that even the company's models, even the evidence from the company's expert, that 2/3 or so of them came in lower. That was my understanding of what the point was.
And typically, Your Honor, it's also important to understand that the expert witnesses who run these models understand them very deeply. They present their models as models of objectivity, and in doing so, it's not uncommon for them to run multiple runs of a particular model to show how different inputs affect the output of the model. They may run what are called sensitivity analyses. So although the company's experts may well have presented a number of different runs of a particular model, and they may have shown some variability, that would also typically be accompanied by testimony that explains why that variability is there and why those models were run. In this case, however, the court really needn't look any further than the discounted cash flow or the DCF models that were run, because the DCF models themselves produced estimates that ranged between 7.5% and 10.88% among all of the parties that presented evidence in the case. And the department in this case expressly found that those DCF analyses were logical and reasonable and a credible basis for determining the company's ROE.
Excuse me, counsel.
Okay.
Excuse me, counsel. That's a big range, 7.5 to 10.88. So your position seems to me to be that as long as the department doesn't outright reject any party's model, it can take what is a very large range, select a number within that range without explaining how it did so, and then that is unassailable on judicial review.
Well, in this particular case, there is a broad range of values because that's the evidence that the parties put before the department. And in this particular case, the department did express a preference for the DCF analysis. It looked at the other analyses and the other models that were also presented, but certainly it found that the modeling that was prepared by the parties that did present that range did provide a credible basis for determining the ROE in this particular case.
And then it can just pick any number within that range?
Well, in this case, it did pick a number within that range.
Right, and I'm asking whether somehow picking a number within the range provided by the parties' models insulates that decision from judicial review.
Under the SJC's precedent, including Boston Gas and Boston Edison, the substantial evidence is the range that is provided by the parties that the department determines to be reasonable.
Those are substantial evidence cases. This is not a substantial evidence case. It's whether we can ascertain from the department's reasoning how it arrived at the number 10. And just in that one snippet of the department's decision from Boston Edison that your sister referred to, you can tell the difference in the quality of the explanation in that case versus this case.
So one issue that I think is important for the court to recognize is that the case the Attorney General relies on, that they appended to their brief, is the wrong Boston Electric case. So if you review the Boston Electric case, you'll see that's an appeal from two different decisions of the department. One decision was called 18200. The other decision was called 18515. And the Attorney General attached the department's decision from 18200, which was a part of that appeal, but it wasn't the part of the appeal for ROE. ROE came from decision 18515, and that isn't attached, and it's not in the record. But even 18515, which is the decision that was appealed in Boston Edison, there were not 70 pages of ROE analysis in that decision. I mean, these are decisions from the late 70s where the nature of the analysis was done differently than it is today in terms of the number of the models that are relied upon and the department's understanding.
Can I interrupt you for a second? Because
Certainly.
what I still am not hearing an answer to my initial question, which is why 10%? In other words, we now know about the models. We know that the range was 7.5 to 10.88. We know there's 70 pages of Hearsay analysis, but at least we can agree that a lot of description of what was presented. But why 10%? Why that number? Granted, it's within the range, but why 10 and not 9.5, 8.8, 9.1?
And that is an exercise, Your Honor, of the department's judgment. This is not a mathematically driven.
Justice Shin has, would you agree with her point that then, as long as you've chosen a point within the range, that then you're insulated from further scrutiny?
On this record, that would be accurate, Your Honor. As long as it was selected within the range of the analyses that the department concluded were credible and sufficient for determining the ROE for Eversource, that's correct. And in this case, the department looked both at the models, which provide estimates, and the department makes that clear in its order. These are estimates of ROE, and the department exercises its judgment based on those estimates, as well as the qualitative evidence that was submitted and is in the record. And so the department looks at this as a composite, just as the SJC has asked the department to do, and has observed that that's how this process works. And
I fully appreciate the standard review here and the deference to the department and the cases, of course, that you cite that repeat that. But I'm also concerned about the fact that when we talk about this range, 7.5 to 10.88, we're talking about millions and millions and millions of dollars. And it's not just a small percentage point that doesn't have actual value to the company as well as to the ratepayers.
And Justice Vuono, it's also important to keep in mind that, as the SJC has recognized in Wolf and other cases, when the department performs the function of rate making, it does this in the public interest. So the department is looking at not only the customer's interest, but also the utility's interests. The department needs to ensure, pursuant to Hope and Bluefield, that the utility has adequate access to capital, can obtain debt on reasonable terms. And so the department has to keep all of these interests in mind when it establishes ROE. The department its purpose is not to set an ROE that is unreasonable and is only beneficial to the utility. The department is charged with acting in the public interest and setting an ROE that will ensure that the utility maintains its financial health, which will allow it to.
Isn't it all that much more important that it explains how it arrived at its decision?
And it does, Justice Shin. It does. There are peppered throughout the 70 pages of analysis on ROE. The department does provide insights and does characterize and critique the evidence and the models that have been presented. Does it reduce it to a mathematical formula? No, it doesn't. I will give you that. But that's not how the determination is made. It's not as
But
though
how
the
about this? Of course, you're correct, and the case law says that a mathematical equation is not what's required. But in this case, the Attorney General had written a letter to the department. I know that you say that the letter should not be considered by us. We should not take judicial notice of it because it's not in the record. And you don't have to comment on that because we both briefed that well. But how difficult would it be, or would it have been, for the department to have responded even to this initial lawsuit in a way that just simply explained more clearly what it was doing, rather than be here, have this full argument, and we will decide whether or not we're satisfied with their answer or not? Is it too much of a burden? Perhaps I don't understand the nuances here.
And I don't know that it's a question of burden, Your Honor. It's just fundamentally how the analysis is done. And the Commonwealth is not like out on a limb, and the only jurisdiction that does rate making in this manner. We cited numerous cases from other jurisdictions that view ROE as the zenith or the apex of the department's exercise of its legislatively conferred judgment. And one of those cases that's interesting is a Supreme Court case out of Colorado Municipal League, 687 P. 2nd at 428. And they used interesting language in that case where they said, we decline to impose an artificial pseudoscientific precision on the rate making process. This is just not how it is done. That court went on to say,
would you say that there would be some a requirement of a change in legislation in order to achieve what the Attorney General is requesting here? In other words, the Attorney General's brief cites to two different states, Alaska and Connecticut, if I'm not mistaken, where there's the information is presented differently. I'll put it that way. Do you think that would require legislation rather than judicial decision making?
So, Justice Vuono, it's black letter law in the Commonwealth that the rate making function is in the first instance a legislative function. If the legislature wanted to engage in this process of rate making and fixing ROEs, it can have at it, right? This is a legislative function. Instead of the legislature performing this function, they have taken the complete scope of public utility regulation, including the determination of ROE, and they have taken that and they have asked the Public Utilities Commission, or asked the Department of Public Utilities to take on that role in its discretion based on its expertise. So if the legislature wanted to change how this is done, they have the power to do that.
Thank you for answering my question. Your time is actually up. We're on another timer now, so we're about less than a minute over. I want to thank you both very much for your arguments. But before I let you go, Attorney Hewitt, I want to go back to see if anyone.
Could I ask one
Sure.
question, Justice Smith? It's the same question I asked your sister counsel, which is, why isn't Eversource a party to this appeal?
Ms. Tepper and I don't agree on a lot in this appeal, but I think her answer is probably spot on. I suspect, I don't know this for sure, and this is speculation that I'm doing, after the clock has expired, so I hope you'll take it for what it's worth. But I suspect that they just felt as though this is a department decision and this is a department process, and this is a decision for the department.
Well, I mean, they haven't appeared at all. They haven't filed anything. They haven't joined the arguments in your brief. They're the real party in interest here.
Well,
they've sought and received a rate increase that they're now going to pass on to 1.5 million of their customers. It strikes me at a minimum to be unusual that they're not here defending their position. Should we presume that they can't defend the decision?
With all due respect, I would not characterize this as unusual that the utility does not appear. I know they do at times,
it's
but
unusual.
Okay.
It's unusual. It's not a bit unseemly that they're not here and they haven't filed anything.
They
I mean, I know they're not your client, but I mean, you're here representing the department's institutional interest. And it seems to me, though, that the utility, before it passes on this rate increase to its customer, has the obligation to come in and defend its position. And simply because their interest aligns with the department's institutional interest doesn't relieve them of that obligation. I do think it's unusual.
Okay. And again, Justice Shin, I appreciate that perspective. However, this is a decision of the department that the department is defending in terms of its exercise of judgment based on the record that was presented. And I'm not aware of a rule that requires them to be a party to the appeal. And I'll just leave it at that.
Okay. I'm checking the panel one more time to be sure there's no other outstanding questions. I see that there's not. I want to thank you both very much for helping us out with this case. We will take under advisement, get back to you as soon as we can. And in the meanwhile, we hope that you and your families stay safe and healthy. Zoom, the regular rules of appellate procedure that apply to oral arguments in the courtroom apply equally to arguments on a remote platform such as this. You've already split your time. We've already reviewed that, so you will be prepared for the watching the timer when it comes up and tells you when your time is up. During the course of our arguments, we may experience some technical difficulties. We hope not, but if so, we'll ask for your patience, and we will be patient with you as well. So that this case I'm going to call is Robert Germinara, I believe. You can correct me when you come on. Thank you. Versus People's Comprehensive Mortgage. The number is 2019-1805. And Attorney DiNardo, you go first.
Thank you, Your Honor. May it please the court. My name is Patrick DiNardo. I represent the plaintiff appellants in this appeal. With me on brief, I just want to note for the record the able assistance of my associate, Nathaniel Kosloff, who's actually watching on YouTube while he awaits the imminent arrival of his first child.
Oh.
So I'm glad I didn't share the participant information with him. I didn't realize I couldn't do that since he would be sitting next to me in court.
Yeah.
Your Honor, this case, obviously, from having read the briefs, I'm sure the court knows, involves an illegal loan, a usurious loan that was a violation of Chapter 271, Section 49, and a litany of other wrongful activities of the defendants, which the plaintiff appellants believe warranted a finding of a 93A violation. I'd love to tell you the case law says that an illegal loan, usurious loan, is per se a violation of 93A. There was some case law to that effect, but the SJC in the Claremont case made it pretty clear to us that, and I'll read the language, whether a particular violation or violations qualify as unfair and deceptive conduct is best discerned from the circumstances of the case. So in the course of my argument, I'd like to run through 6 elements of the wrongful activity that I'd like to highlight for the court. It's a complex case, and it took 12 trial days and 156 exhibits. 15 minutes is going to be hard to do justice to it, but I just want to tell you what I'm going to tell you, which is the 6 elements of the wrongful activity of the defendants, which I believe the Superior Court clearly erred in disregarding, minimizing, or completely ignoring in some instances. And then the court misapplied the law, this court's case in Levinson about wrongful foreclosure, and also misapplied a case out of the District of Massachusetts, U.S. District Court case called Kershke, which dealt with whether a debt would be extinguished upon taking deeds in lieu and recording them. That's what I'm going to tell you. So let me start with the illegal loan. There's no dispute about it. The loan here was at a rate well in excess of 30%. The defendants had been doing it for decades. They're loaning at these rates. They had a protective notice on file with the Attorney General in 2008, and I believe they consider it an administrative oversight that they didn't renew it after it expired in 2 years. So by the time of this loan in August of 2010, there was no protective filing, and the loan itself was a violation of the usury statute. Now, there's nothing normal about this loan. The money ostensibly came from People's Comprehensive Mortgage. I'll refer to it as PCM. But in fact,
Can I ask you a question for a moment?
sure.
Let's assume that assuming for a moment we share your view that there was nothing usual about this loan. The judge did find specifically that your client knew exactly what he was doing and agreed to the loan voluntarily. So and that was based on, more than anything, his determination of credibility. So what do we do with that?
What do you do with that, Your Honor? Well, desperate borrowers tend to agree to what they need to get the loan, and that's why the law makes it illegal to do it. Because as one commentator talked about, it's a necessitous borrower is desperate and will sign just about anything to get the loan. Now, Mr. Germinara had put up a $43,000 deposit to acquire the gas station. That was a huge amount of money for him, and he couldn't get conventional financing, and unfortunately he made a bad decision to deal with the defendants in this case. And the rate I calculated as 36%. There were $70,000 in charges for cash that was advanced to him initially of $380,000. This was a 6-month loan. When I do the math, that's over 36% interest. The statute says anything over 20% is illegal unless there's a protective filing with the AG's office. And clearly there's an admission here that the AG's office had one in 2008 that had expired. So my client's desperation to get this loan and complete the sale and not lose his deposit is not material to the fact that there was an illegal loan. But that's just the beginning. So that's the first of the 6 elements. There was an illegal loan, a wrongful foreclosure, unfair collection practices, excessive demands, deception about the stated sales price of the collateral, and then finally a false affidavit that was filed in connection with this case. And I note the case law cited in our brief that says the way a party conducts the litigation is also relevant to the 93A violation. So we've talked a little bit about the illegal loan, and what I was trying to say is that there's nothing normal about this. The commitment letter is signed and issued over the name Peter Bacchus as manager of PCM when he never was the manager of PCM. It turns out the closing attorney, Mary Ellison, signed his name, but was directed to do so. And Peter Bacchus was involved in every aspect of the negotiation of the commitment letter, so he knew she was issuing it. The relevance of that is that in the false affidavit that was filed later on by attorney John Hanna, who represented PCM at the time, and this is docket number 21 in the underlying case. It was an affidavit that was filed in April of 2014. Mr. Hanna was suggesting that the Bacchus signature was a forgery, as if my client had somehow forged the commitment letter that led to the loan that PCM closed. The other strange aspect of the loan here is that the interest was going to be prepaid $40,500, and there were 5 points of origination fees, so $63,000 of that $70,000 I mentioned. The other $6,000 or $7,000 was closing costs, all of which is calculated as interest under the statute.
Counsel, could I interrupt you? I'm having trouble understanding the injury here, where your client didn't make any payments on the loan, and I don't see any evidence or findings that it was because of the usurious rate, that's what caused the default. So could you address that?
Yes, Your Honor. He wasn't required to make payments during. It was a balloon note, so he wasn't required to make payments during the course of the note, which originally was for 6 months and was extended to 12 months. The injury here, I'm glad you asked that question, because the injury here was that the defendants took 2 properties from my client, which he believes are worth well in excess of $1 million. Supposedly in satisfaction of a debt that at most was around $525,000 at the time they took those properties. So the injury here, the primary injury, is that the defendants acted to deprive my client of that surplus, the equity in his property.
That's not related to the rate, right? I mean, so he defaults And it had nothing to do with the rate, right? The judge made a finding that there is no way he could pay even the principal off by the time of the default. So the taking of the properties to me doesn't seem to be at all connected to the usurious rate.
Well, that's right, Your Honor, but
Okay.
it's definitely related to the second element of the wrongful activity, which is the wrongful foreclosure. And so the wrongful foreclosure aspect of the case, the Superior Court just never could appreciate the Levinson decision. He considered taking deeds in lieu of foreclosure at the time of the loan closing to be a common practice. And there's no evidence to support that. In fact, there are authorities to say, and one of the articles is Bad Timing for Deeds in Lieu, which says taking deeds in lieu at the time of the loan closing is always invalid. And that's exactly what that's an article about case law in other parts of the country, but that's consistent with the Levinson case. And the Levinson case is crystal clear that when you take the deeds in lieu at the time of the loan closing, they're invalid. And when you take the next step of recording those invalid deeds, you've engaged in a wrongful foreclosure. The Superior Court agreed with us that the 2010 deeds in lieu were void. He refused to take the next step to find that recording them was in and of itself a wrongful foreclosure.
So I hate to sound like a broken record, but what is the injury from the recording of the original deeds in lieu?
Again, Your Honor, when they took the two properties from him, they took the surplus value, his equity in that property.
Okay, but
At the time they took those loans,
it seems to me your position depends on us overturning the judge's finding regarding the later deeds in lieu, which the judge found were lawful and validly transferred title.
Well, I think we are entitled to press a claim for wrongful activity, which occurred before and after the 2012.
Right, but as far as proving 93A damages, if you accept that the later transfer of title was valid when the new deeds in lieu were executed, then it's hard. I guess I'm not understanding what injury was caused by the earlier recording.
Well, when they recorded those deeds in lieu, they started causing my client to pay rent to stay there. And so he paid rent after September of 2011 when the defendants recorded.
There's no dispute that at that time when you started paying rent that he was in default, right? So I mean, so if let's just say, for example,
he was in default of an illegal loan, correct?
Right. Okay, but let's just say, for example, had the defendants not recorded the deeds but instead went through the foreclosure process, then we'd have no issue, right?
Well, if they had gone through the proper foreclosure process, Your Honor, my client did find a financier who was willing to help him try to take out the defendant's loan in their position. And had this been properly noticed in foreclosure, that person was an adjacent property owner. He would have gotten notice of the sale. He may have come to the fore earlier. He came to Mr. Germinara's rescue and was trying to buy out the defendant's position, but that's one of the excessive demands. At that point, they wanted $850,000 to get taken out.
Is that in the findings, what you just said?
The $850,000?
No, about the neighbor.
Mhm.
Well, it's in the record. Mr. Lagasse testified undisputed about it, that they offered $500,000 to take out the defendant's loan position. And as it turned out, they demanded $850,000 at this point.
Okay.
Your Honor, it's important to note that when they took the deeds in lieu, that followed a demand letter. It's Trial Exhibit 109 in the appendix, volume 7 at page 17. The demand was August 25th, 2011, so 6 days before the maturity date, and they said they wanted to be paid $611,000. When you look at the numbers that they say total to $611,575, the numbers actually total up to $586,000, and this is based on the usury. These are their numbers based on the usury. So I see I only have 4 or 5 minutes left. I just want to go through the unfair collection practices, which post-date the 2012 deeds in lieu. When they couldn't come to terms in the end of 2013 on a buyout of the defendant's position for the excessive demand of $850,000. that's when the defendants started turning up the heat. They stripped the 1 Kent gas station of all my client's personal property. And then they had an exchange where the lawyer for PCM tells Nick Bacchus, let the police know that Germinara is a trespasser. Hopefully they won't figure it out. And so there's a police report where he then makes that call and he accuses Germinara of being a trespasser. And then the police act on that and they give my client 2 minutes to get off his property. They knew the proper way to proceed was through summary process. They had drafted a summary process summons. My client said he went to the hearing and there was nobody there, so he went home. But instead of pursuing summary process, because my client's leasing the property at this point, there's no way he could be considered a trespasser. They went and reported to him, and the judge minimizes that, and he says, well, I can't see a cognizable injury. But they got him off the property so they could then strip 77 Parker Street of all the valuable personal property that was there. This is after they took the deeds in lieu and extinguished the debt. And that's my last point about the Kurshke case. The judge relies on this Kurshke case out of the District of Massachusetts to say, well, there was really only a partial extinguishment here. And, you know, I can see a case Kurshke where this is, but relying on Kurshke was completely inapposite, because Kurshke, there was an explicit understanding about a partial reduction. And in this case, my client has said from day one that 77 Parker Street alone, he would never consider selling for less than $1 million. It had the real estate, but it also had extremely valuable flammable permits. And I would note, Your Honor, that if you look at Trial Exhibit 91, the buyer who acted through an individual named David Cowie recognized the value of the permits, because he's talking with Nick Bacchus about their interest in buying that property. And he says transfer of the permits is paramount.
Are you making a legal argument here or a factual argument? Are you arguing that as a matter of law, the deed in lieu did not extinguish the debt in its entirety? Or are you saying as a factual matter, there was no deficiency, or both?
I'm saying that the deeds in lieu could not vitiate the wrongful conduct. They were not a release for the wrongful conduct that occurred before and after. That they certainly, there was no deficiency claim as a matter of fact, because the properties were worth well in excess of any debt that the defendants could claim.
Okay.
And in fact, PCM's attorney acknowledged as much. He said taking the deeds in lieu cuts off the deficiency
So
claim.
you're making a factual argument. Are you also making a legal argument? Because it seems to me that Kurshke is at least analogous, because here the deeds say that it's in satisfaction of the existing mortgage, not the underlying debt.
Well,
So as
Your
a
Honor,
legal matter, it's hard to see how it extinguishes the debt in its entirety.
It absolutely did, because it's a question of the valuation. Kurshke, they agreed the value of the property being transferred was less than the debt. In this case, we've never agreed that the value of the property was less than the debt.
But that's a factual argument. I'm just trying to clarify what you're arguing. That seems to me to be a factual argument, that there is.
It is, Your Honor. It is, Your Honor. And they had their own appraisal that said the property at the time they took it was worth $730,000. These are their own numbers.
Okay.
Your Honor, I think the false affidavit, my last piece, I have a few seconds left. Mr. Hanna was suggesting that the origination fees were not collected, and that's just completely and utterly false. Thank you.
Thank you very much. Thank you for your argument. Okay, so we're now going to turn first to Attorney Curtis, correct, for 9 minutes?
Correct, yes.
Okay, please go ahead.
Okay, Attorney Robert Curtis for the appellee People's Comprehensive Mortgage. May it please the court. I definitely want to get right into this issue about factual questions. Most of what the plaintiffs are arguing here are fact-based questions, and that's subject to the clearly erroneous standard. And we've got 103 pages of very detailed findings showing that the judge paid very careful attention to all of these facts. There's no chance of demonstrating that these findings are clearly erroneous. So that's really our starting point here with most of the plaintiff's arguments. Most of them are challenging the manner in which the judge found the facts, and there's simply no basis to overturn those findings. But then, I think the plaintiff's case there's a lot of information here, and there's a lot of arguments that sort of blend together and maybe not even very clearly. And I think what we tried to do in our brief is really get to the meat of what this case is about. First issue was the usury issue. And the case law is clear that a violation of the usury statute doesn't necessarily require rescission of the loan. So there's a lot of characterizations here about this being an illegal loan. And yes, while the loan ultimately ran afoul of the usury statute, mainly because the PCM failed to file the statement with the Attorney General's office, the mere fact that it ran afoul of the statute didn't mean that it had to be rescinded. And there's case law authority that really plaintiffs don't even address, that says that it's within the judge's discretion to reform the note when it violates the statute. And that's exactly what the judge did here. And he didn't abuse his discretion. An abuse of discretion is when a judge fails to apply the relevant standards so that the result can be questioned. And when you look at these findings, the judge addressed all of the relevant standards to reforming usury. And many of these factors have to do with, the purpose of the usury statute, which was originally, to, prevent organized crime figures from lending at exorbitant rates. That certainly wasn't an issue here. What we had was, two parties who were experienced in business deciding to make a high interest loan because it was high risk. And the judge found that. And the judge found that the plaintiffs were at all times, adequately represented by competent counsel. There really was no reason to suggest that the integrity of the loan was invalid. Yes, it ran afoul of the statute. That needed to be corrected, and the judge did that by reforming the rate. And by the way, ultimately, once the judge did reform the rate, we really don't have any arguments on appeal from the plaintiff challenging the rate that was ultimately applied. So when we eventually get to the damages calculation, there's no arguments here. Any argument about that rate has been waived at this point because it wasn't raised. So the judge applied this new rate, and that's where the damages calculation came from. So on the usury issue, it's clear that the judge followed the relevant factors and exercised his discretion appropriately. So then the next question we get to is the questions of these deeds in lieu of foreclosure. Now, there's no dispute that the earlier sets of deeds in lieu weren't valid. Again, they're characterized as illegal or wrongful and things of that nature. Essentially, what happened was the parties tried to accomplish something that didn't work with those earlier ones. So deeds in lieu got recorded. Ultimately, the judge determined that those earlier deeds in lieu were nothing more than equitable mortgages. So it's not that they had no value, they just didn't have the value that the parties had intended initially. But all of that at this point is a moot point, because in 2012, after the default, there's no dispute the default occurred in August of 2011. So after that point, we have a new set of deeds in lieu, April 2012, and those ones effectuated what the parties really intended from in the first instance. It effectuated a transfer of title of these properties in satisfaction of the mortgage. Again, not in satisfaction of the note, not in satisfaction of the debt, just in satisfaction of the mortgage. And that's expressly what was on there. Now, plaintiffs challenged the deeds in lieu on several grounds, but none of these have any effect or invalidate these deeds in lieu. They argue that that they were a forgery, but the judge, again, we're talking about a finding of fact now, the judge found these weren't forgeries, that Mr. Germinara actually signed these. And in their brief, the plaintiffs argued that the judge relied, I don't remember their terminology, but essentially that the judge based this finding on the notary seal. And the judge expressly said the opposite. He says, I don't need to rely on the fact that this was a notarized document because I find Mr. Germinara actually did sign these documents. So the fact is that the deed was delivered, it was properly signed, executed by Mr. Germinara and delivered. transferring the title. They argue that that there were formal defects involved in the 2012 deeds in lieu. But again, these arguments don't carry any weight. They claim that there was no valid consideration on these 2012 deeds, but each of the 2012 deeds expressly said this is in consideration of the discharge on these mortgages. And it doesn't have to be a pecuniary amount to have consideration. The law states that you can have as consideration something other than that, like, for instance, discharge of the mortgage. They argue formal defects in the form of no property description, but the judge didn't find that. The judge found A, Mr. Germinara absolutely knew what properties he was transferring, and B, that there was an attachment A or exhibit A to these deeds that adequately described the property. Furthermore, as a matter of law, the lack of a description doesn't invalidate a deed. It's just potentially going to have an effect on the recording process. But that's not what's in dispute here. They're claiming the deed was invalidated by the lack of description. And right in the statute, it says that that's not going to invalidate. Then they argue that there was no date on these 2012 deeds. Again, the fact that there wasn't a date doesn't matter. That's not the operative issue. The operative issue is whether there was a delivery. The judge found that there was. And so it doesn't matter. But not only that, the documents all were dated April 5th. I believe there was only one document that had a missing date in one place, but that date appeared elsewhere on the document. So it's really not an issue, and the judge found that it wasn't an issue. So in that sense, you know, there's nothing to overturn here. Then let me jump, since I see my time's waning here. The 93A issues. In each case, the judge carefully balanced all of the factors and weighed all of the factors that are relevant. Plaintiffs had to show an unfair or deceptive act or practice. They didn't satisfy the judge that was shown here. And so the judge was well within his discretion to find that there was no 93A value. Okay, I see my time is up. There's no questions, obviously, so thank you.
Thank you very much.
If I may ask one question, I actually think you had one more minute, but in any event, on the attorney's fees, how do you respond to the argument that the plaintiffs prevailed on one count of their complaint?
Well, so even to the extent that they prevailed, the agreement between the parties was that PCM was entitled to cost expenses, including attorney's fees, for enforcing the note, and as a matter of law, and in some of the documents, that includes defending the note. So ultimately, PCM was successful in doing those things. Just because the plaintiffs throw several counts out there and maybe one of them had some merit, doesn't mean that PCM still didn't have to go through all of this effort to recover the funds that they were entitled to. And since the agreements provide for attorney's fees in this situation, then PCM should be entitled to them.
So did your clients argue in the trial court that the loan was not in fact a violation of the anti-usury statute? Or was the fight more about the remedy?
It was more about the remedy, to the best of my recollection. I was not the trial attorney, so I don't have a clear recollection on all of that, but I think the point really was more that it was the remedy should be reformation, not rescission.
Okay, thank you.
Okay. Thank you. We'll turn now to Attorney Littman.
Thank you. Good morning. Adam Littman on behalf of the Bacchus parties, Peter Bacchus and his sons, Nick and Danny Bacchus. I want to start by just saying that, you know, the Bacchus parties were the group that funded the loan that PCM made to Mr. Germinara and his entities. They're the real victims in this case. They lost hundreds of thousands of dollars on a loan that was never paid. They invested thousands of additional dollars into additional loans that were made to Mr. Germinara and his entities. And they put money into the gas station to operate after Mr. Germinara failed in operating the station. They lost all of that money. They are the victims in this case. They did not engage in any unfair and deceptive conduct. I would agree, the Bacchus parties fully agree with PCM's position that there was no that the standards of review in this case are just not met. And I think the appeal really begins and ends with on that issue, that the appellants have the burden of showing that the judge's findings of fact were clearly erroneous. And there's extensive evidence to support all of the judge's findings in this case. The appeal is really based upon evidence and testimony that Mr. Germinara proffered at trial. And the judge went to great length and explained that he did not credit Mr. Germinara at Mr. Germinara's testimony. So there's no reason, there's no way that we're going to be able to argue about credibility here. I mean, the judge made credibility determinations against Mr. Germinara and in favor of PCM and the Backuses. And that should really be the end of the matter as far as the Backuses are concerned. The Backuses are aligned with PCM in that the rate of interest that was applied and the deeds in lieu of foreclosure do not constitute 93A violations, that the judge properly dealt with those issues very carefully in his decision based on the case law. There was a question a moment ago by Justice Shin about whether there was an argument whether the loan was not usurious to begin with at trial. That argument was made by both PCM and the Backuses. There's a provision in the note that specifically says that in the event any charges are deemed to be excessive or unlawful, the rate will automatically be brought down to the maximum allowable rate. The judge really, I think in his decision, explained that he agreed that the parties had already agreed that reformation was the proper remedy. So while he had the discretion to reform the loan, he acted in accordance with the parties' agreement. So I want to focus in on two additional topics. One is I'm going to deal with this alleged unfair and deceptive collection activity that occurred well after the loan was made and defaulted on. And secondly, I want to touch on an issue that we raised in our brief, which the judge did not even get to in his findings and rulings, which he didn't have to, which is that Mr. Germinara and his entities waived any claims against the Backuses in this case. There was a commitment letter that Mr. Germinara signed prior to the loan after consulting with his counsel, in which he agreed that in the event of any dispute with respect to this loan, he would look solely to the lender and not any of the lender's agents, incorporators, members, managers, etc. The Backus parties funded the loan. They did not make the loan. This was a PCM loan. And Mr. Germinara and his counsel understood and agreed that PCM was the lender, and to the extent there was any dispute with respect to the loan structure, our position is those claims could only be made against PCM and not the Backuses. With respect to the unfair and deceptive collection activity, I think, again, we're going to have to wade deeply into the facts and the evidence in the record. And I think when you look at the evidence that the judge relied on, it's clear that the findings were appropriate and well supported, and that there was no unfair and deceptive conduct. Attorney DiNardo said that the Backuses went into the gas station and stripped it of all of its contents. If you look at the judge's findings and Nick Backus's testimony, they went to the gas station at the direction of Mr. Hanna, who was acting as legal counsel at PCM at the time. The property was being rented to a new tenant. They had to clear the station out for the tenant. When Peter and Nick Backus arrived at the station, Mr. Germinara appeared. They told Mr. Germinara what they were doing. They offered him an opportunity to remove all of his personal belongings from the gas station. He spent an hour removing his stuff. And then the Backuses followed Mr. Hanna's direction and brought the rest of the contents to a storage facility, and it sat there. They didn't convert that property, and the idea that they were somehow being unfair and deceptive is just not supported. The party spent a lot of times in their briefs, and Attorney DiNardo mentioned it, that the Backuses reported that Mr. Germinara was a trespasser at 77 Parker Street. I think if you wade into the evidence and the documents, you'll see that there were two totally unrelated events that occurred at Parker Street in 2014. First, Mr. Hanna in January of 2014, directed Nick Backus to post the sign with no trespassing signs because Mr. Germinara, although he was being in the process of being evicted by PCM, was illegally renting spaces to commuters who were parking at Parker Street and then going to the commuter rail stop that was nearby.
Attorney Littman, I want to interrupt you. I'm sorry. The timer, as was explained at the beginning of the argument, the timer was going to go out at the 1 minute mark because that is actually corresponded to the 6 minutes that we just weren't able to set the timer that way. So your time is actually expired. I'm going to give you a moment though to sum up. I've only first checked to see whether or not anyone in the panel has a question for you. No, okay. So you can either rest on your brief or I can give you just a few seconds to sum up.
Yeah, I'll just conclude that last point regarding the trespassing issue. The judge found that no one intentionally lied to the police that Mr. Germinara was trespassing. If you look in our brief, we've cited to the testimony of Nick Backus and we'll rest on our brief on that issue. Thank you very much.
Thank you all three very much. We'll take the case under advisement. We'll get an answer to you as soon as we can. I understand, Attorney DiNardo, you're going to be here for the next case as well, but you'll have to get off and go into the waiting room and be readmitted. Again, we'll take the case under advisement. And in the meantime, we wish you, on behalf of the panel, that you and your families stay healthy and well during this health crisis.
And same to you, Your Honor. Thank you.
Thank you.
We are live.
Thank you. Welcome to you both. Attorney DiNardo has already heard my introduction, but for your benefit, Attorney Vesely, I want to introduce the panel to you. I'm being joined today by Justice Jeffrey Kinder and Justice Suk-Young Shin, and my name is Ariane Vuono. Thank you for participating via Zoom today. As you know, you have 15 minutes to present your argument on your side. We'll begin with Attorney DiNardo. If we have any technical glitches, we apologize in advance, and we hope that you'll be patient with us while we resolve them if they do occur, and we will be patient with you as well should you experience any problems. So this is the last case we're going to be hearing this morning. It's Mr. Germinara versus Plum Island, LLC, 2019-1843. And Attorney DiNardo, you'll begin this argument again as well. Thank you.
Thank you, Your Honor. So this case is ancillary to the case we just argued. Actually, given statute of limitations issues, we felt we needed to bring the action to preserve my client's right to get the property back in the event that the Superior Court agreed with us about the wrongful foreclosure and the wrongful actions in the underlying case. It's our view that when the Superior Court found that the original deeds in lieu were void and based on the Levinson case, should have found that the recording of those deeds in lieu taken at the original loan closing was itself a wrongful foreclosure. That 2012 deeds in lieu that we were discussing earlier were confirmatory and took the place of the original deed, and therefore create no title in and of themselves. Therefore, PCM does not have good title to be able to transfer the properties to the buyer here, which was a special purpose entity created by an individual named David Cowie. The transferee was called Plum Island LLC. Mr. Cowie was the chief operating officer for a company called Enpro that had been a tenant on 77 Parker Street. They're only dealing with that particular property. As it turns out, the 2012 deeds in lieu were deficient on their face. And I understand that the court ruled against my client when he testified he hadn't signed those deeds in lieu. It was our position that they were a forgery. The judge didn't accept that. And I accept that he has the ability to make that credibility finding. But the 2012 deeds in lieu were further deficient on their face. They were blanks that Plum Island's attorney felt he needed to fill in order to be able to record that deed when Plum Island was moving to buy the property. And the court didn't consider the blanks that were filled in by Mr. Adams, who was the attorney for Plum Island, to be material. But if they were not material, then I asked the court, why would Mr. Adams have felt the need to fill them in? And more importantly, he asked permission. He knew he needed to ask permission to fill the blanks in. The only problem is he asked permission to Mr. Hanna, who was the PCM attorney who was involved in disposing of the property. He didn't ask the supposed the signer, Mr. Germinara, for his permission to alter the form of the deed. So he knew he needed to fill the blanks in. He knew he needed to ask permission. He filled the blanks in, asking permission to PCM's attorney, but not the person who actually signed the deed, the grantor, supposedly Mr. Germinara. So I think given the law in Scapland, which is a 1904 case, makes very clear that a confirmatory deed does nothing but take the place of the original transfer. The original transfers were the void deeds that were recorded in September of 2011. This supposed confirmatory deed was signed in April of 2012, the defendants claim, but it wasn't actually recorded until the time property was being sold. And the significance of what was going on here, it's not just the alteration of the deed that we say is wrongful. Mr. Cowie wanted this property, and he had had exchanges with Mr. Germinara going back to the beginning of 2011. There were two elements to the value of 77 Parker Street, the real estate and the flammables permits to store 303,000 gallons of flammable hazardous waste on that property. Enpro was an environmental cleanup company. It was important for them to want to have the ability to store their hazardous materials in those tanks. Mr. Germinara spent 21 years on this property, developing the property into a storage site, a unique storage site in the Newburyport area. The permits alone were at least $500,000 in the value when Mr. Germinara told Mr. Cowie, I would never sell this property for less than $1 million. Approximately $500,000 for the real estate and approximately $500,000 for the permits. The significance of all this is Mr. Cowie knew exactly what he was doing when he was dealing with Nick Bacchus at the end of 2011 after PCM had taken the properties. It was trial exhibit 91 in the underlying action. Mr. Cowie was talking about his interest in, he was still interested in buying the property. And he said the transfers of the permits to the new owner is paramount. He knew exactly that that was a key element of the value here. And when he bought the property from PCM, PCM either didn't understand the significance of the permits and the value there, or just didn't care about it. Now, there was an email exchange, we call it the Mabardi side deal email in the underlying case, where Mr. Hanna was explaining to one of the other attorneys for the defendants in the case that the sales price of the collateral when they were disposing of the collateral was going to be in line with the amount claimed under the note, so they could eliminate the perception that there was a surplus that they were stealing from my client. And in fact, I say it that boldly because they did steal the surplus from my client. There was equity in that property. They took the deeds in lieu at closing so they could execute on a wrongful foreclosure. When Mr. Cowie pointed out to Mr. Bacchus in that email, which is trial exhibit 91 in the underlying case, that we need the clear title. Mr. Cowie knew in November of 2011, 2 months after PCM had taken it, that was a wrongful foreclosure and they needed the clear title. They came up with the strategy of having confirmatory deeds, but the confirmatory deeds did not vitiate the wrongful conduct. They're not releases. They were an ingenious method to complete the theft of the equity value, the surplus in the property. Now, the court decided to say that the 2012 deed was not a forgery. Let's assume, and I don't acknowledge this because my client testified quite clearly that he did not sign the 2012 deed, but let's accept for purposes of argument that he did sign the deed. Would he willingly give up $1 million worth of property value at that time Is there anything to indicate that he was willingly giving up the property value that he perceived to pay a debt, which at most, even as it was reformed, was about $525,000 at that point? Why would he give up over $1 million worth of property to satisfy a debt? Now we've talked about the satisfaction of mortgages. Mortgages aren't satisfied. Mortgages are discharged. Debts are satisfied. Debts are extinguished by the deeds in lieu. So maybe the language in the deed in lieu, as it was prepared by the defendants, was inartful. But to talk about satisfying the mortgage and not extinguish the debt when the property is worth well in excess of the amount of the claim is wrong. And that's what this action is about, to try to get either the property back or the value of the equity that was taken.
So counsel, let's just assume that we were to affirm the judge's decision in the earlier case. What issues remain to be litigated that wouldn't be barred by issue preclusion?
Well, the case against Plum Island is more than just the wrongful taking. It has to do with the alteration of the deed, which was the means by which they took the surplus from my client. And it also has to do with the fact that
the judge found those alterations in the earlier case, the judge found that those alterations did not affect the validity of the deed and that title was still lawfully transferred. So
yeah, he found they were not material, and that's an error, because if they were not material, as I was just saying, why would Mr. Adams have felt the need to?
But he found otherwise. He found otherwise, and let's say we affirm that. I'm having trouble seeing what issues are left to be litigated in this case.
Well, Plum Island's agents participated in the dispossession of my client's personal property. They took the permits for no value when they bought the real estate from PCM, and they participated in the removal and destruction of my client's equipment, vehicles, and tools.
So I didn't see that in the complaint, counsel. Did I miss it, or can you point?
Yes, Your Honor, it's in the complaint. I believe it's I'll get the complaint. I believe it's paragraph 69, but let me just
Oh, okay. So it's
yes.
Plum
Island, through its agents, participated in an effort to dispossess plaintiff as personal property. We also talk about it in paragraph 67. Remember, this was a motion to dismiss under 12b6, so these allegations should be taken as true for this purpose. The fact of the matter is, Mr. Cowie was talking with Mr. Bacchus. I believe it was, it's trial exhibit 135 in the underlying case. Mr. Cowie's saying he wants to buy Mr. Germinara's forklift for $1,000. This is one of the items of equipment and personal property that I say that the defendants wrongfully took. If they were taking the real property, which was worth well more than their claim, and it extinguished the debt, why were they taking his personal property and selling that as well? But Mr. Cowie was trying to buy a forklift for $1,000, and he notes in the course of that email that our people assisted in the load out of, he actually says, the Germs property. None of the Germs property will be left on the property. The disdain with which he viewed my client, Mr. Germinara, to call him the Germ, and that his property was taken and removed from. The allegation in this case is Plum Island, and it needs to be responsible for its agent's actions. Its agent, Mr. Adams, in altering the deed. Its agent, Mr. Cowie, and his employees in removing and dispossessing the property. This is a separate cause of action. It's not identical to the action that was brought against PCM and the Bacchuses. It's, in fact, a separate cause of action for separate wrongs. The last point I want to address, and my time is running out, is Plum Island had made the case that 93A doesn't apply here because Plum Island, newly created entity, is corporate separateness, and it really wasn't the actor here. David Cowie and Empro, if they were the actors, Plum Island shouldn't be responsible for them. And Plum Island didn't even actually deal with Mr. Germinara in buying the property. It dealt with PCM. The law on 93A is not so narrowly construed. When Mr. Cowie was trying to negotiate to purchase the property from Mr. Germinara, that was a premise in and of itself for 93A liability. If he ended up in a scenario where they took the property for less than fair value, they participated in the removal of the personal property and the destruction of it. A lot of that personal property, the tools that they removed, they ended up in a dumpster. The boat that Mr. Germinara was working on, the lobster boat, 25-foot lobster boat that he got permits so that he could sell, was towed to a field south of Boston. These items of personal property weren't taken to be liquidated as collateral for some debt and satisfaction of a debt. They were taken to hurt my client. And the email correspondence shows that when Mr. Hanna tells Mr. Bacchus, I'm Winston Wolfe, making people miserable one day at a time, the Superior Court considered that a joke. There's no joke here. This was my client's life work. These were his tools of trade. That's how he made his living. They took everything from him because he wouldn't pay him the $850,000. And Mr. Cowie and Plum Island were very happy to come in and just take the real estate at a time when the other defendants were seeking to minimize the stated sales price. I don't know if they paid separate value for the permits. We couldn't get discovery with respect to Enpro and Mr. Cowie. Judge Cornetta had a very, very narrow view of this case early on based on Mr. Hanna's affidavit, where he was suggesting that the commitment letter was a forgery, and that the only way we get to a usury is if the points were collected by PCM, and they were not collected by PCM. Well, that was such a false and misleading affidavit because the points were actually collected by the Bacchus entities themselves. The prepaid interest went to something called Macedonia Realty Trust, and the points were paid to Blue Hat LLC, Bacchus controlled entities. So he could technically say to the court, PCM didn't collect the points, but it was the Bacchus entities who collected the points, and it doesn't matter under the statute who actually collects the monies. If they're charged, that's a violation of the usury statute. So when the court said below that there was no cognizable injury, I don't know what evidence he was looking at. There was plenty of evidence of cognizable injury, and the Plum Island agents participated in this. And the benefit they received was 77 Parker Street, the real estate and the permits. $1 million in value that Mr. Germinara would never have let go for less than $1 million. They're saying that he willingly signed over those properties by the confirmatory deed in lieu. Well, under the Scapin case, even if he did sign it, it doesn't work. And that's why 93A is as vague as it is about what's unfair and deceptive, because human ingenuity is boundless in coming up with unfair and deceptive acts. And I see my time's expired, and I thank you very much for your attention.
Thank you very much. Okay, we'll turn now to hear from Attorney Vesely.
Thank you, and good morning, justices of the panel. May it please the court. My name is Liam Vesely, and I represent the appellee Plum Island LLC. The issue before you today is whether the Superior Court erred in dismissing appellant Germinara's complaint against Plum Island for declaratory judgment and Chapter 93A violations. We argue that the court, in fact, correctly dismissed the complaint because A, the contingency which may have created an actual controversy to exist between Germinara and Plum Island, that is a favorable judgment in the underlying action, never came to be. B, the very same issues on which Germinara sought declaratory relief against Plum Island already have been adjudicated against Germinara on the merits in a final judgment. And therefore, Germinara is barred from relitigating those very same issues against Plum Island under the doctrine of issue preclusion. C, there can be no Chapter 93A claim asserted by Mr. Germinara against Plum Island because there was never any commercial transaction between the parties. And despite what Mr. DiNardo argues to the court, there are legal definitions as to what constitutes a commercial transaction. It's usually the offering of goods and services and an exchange of consideration for those goods and services. That never happened here. And finally, there are no facts alleging any unfair, deceptive conduct engaged in by Plum Island with respect to Mr. Germinara. Now, Mr. Germinara brought this action against Plum Island for the sole reason that Plum Island was the successor title holder to a piece of property at 77 Parker Street, which it acquired from People's Comprehensive Mortgage. And People's Comprehensive Mortgage, or PCM, acquired title to 77 Parker from Germinara by means of a confirmatory deed in lieu of foreclosure given in connection with a 2010 loan transaction. After that loan went into default, Germinara brought suit in the Superior Court. As you know, you've just heard the appeal on that. Germinara's attempt was to invalidate the loan transaction and have PCM reconvey 77 Parker Street back to him. That's referred to as the underlying action, and that is essentially the claims that were brought in that case. Plum Island had nothing to do with the 2010 loan transaction. It was not a party to Germinara's underlying action against PCM and others. That case went to trial before Justice Karp in the Superior Court in December of 2018. On April 29th, 2019, while awaiting a decision on the underlying action, Germinara filed a suit against Plum Island. Germinara's complaint states right up front that his claims against Plum Island originate from the disputed 2000 loan transaction with PCM and are predicated on Germinara obtaining a favorable decision in the underlying action. The second paragraph of the complaint says, and I quote, "A decision by the Superior Court in the underlying action is pending after a bench trial conducted December 2018. And in the event that the court determines PCM and other defendants in that action engaged inter alia in wrongful foreclosure on 77 Parker Street and other unfair and deceptive actions, plaintiffs seek, among other things, a determination here that Plum Island could not and did not obtain good title to the subject property from PCM." Germinara then attaches a copy of the operative complaint from the underlying action and incorporates its factual allegations into its complaint against Plum Island. Germinara even gives a brief summary of the issues tried in the underlying action, including that the confirmatory deed in lieu and accompanying affidavit, estoppel affidavit for 77 Parker Street were fraudulent and were never signed by Germinara, making them invalid, and that Plum Island's attorney made material alterations to the confirmatory deed, and that 77 Parker Street should reconvey the property back to Germinara. The very same claims and issues in the underlying action have been brought over and transferred over in a complaint against Plum Island. That is obvious from the face of the complaint. 2 weeks after Germinara filed his complaint against Plum Island, on May 13th, 2019, Justice Karp issued his findings, rulings, and order of entry of separate and final judgment in the underlying action. In his findings, rulings, and order, Justice Karp found and ruled that there was no fraudulent scheme to deprive Mr. Germinara of his real estate at 77 Parker Street. The court did not credit Mr. Germinara's testimony that he never signed the 2012 confirmatory deed in lieu and estoppel affidavit, and that his signature was forged and never notarized. Instead, the court ruled and found that the deed in lieu and accompanying affidavit were executed by Germinara freely, intelligently, voluntarily, and with full understanding of their terms, and that his signatures were notarized, and that the 2012 confirmatory deed in lieu and accompanying estoppel affidavit did not constitute a wrongful foreclosure, but rather constituted a valid absolute conveyance of 77 Parker Street from Germinara to PCM. These findings and rulings can be found in the record appendix at pages 155 to 157 and 190 and 192. Those are the findings, rulings, and order. Justice Karp's findings, rulings, and order also reflect that he rejected Mr. Germinara's contentions at trial that the 2012 confirmatory deed in lieu was a nullity for failure to recite consideration, for lack of a property description, and because the date of Germinara's signature lacked a specific numeral date, a day, on two grounds. First, the court found that Germinara waived those arguments for failure to properly support and develop them in trial. But secondly, the court went into substantive reasons. The court found that the 2012 confirmatory deed in lieu and accompanying estoppel affidavit, in fact, do recite consideration. They recite the satisfaction of the existing mortgage from Germinara to PCM. Now, I'm just going to briefly address something that Mr. DiNardo brought up. He made some unsupported argument to the court that mortgages, there's no such thing as satisfaction of a mortgage, that mortgages are discharged. Well, I'm not quite sure what he's getting at. Satisfaction of a mortgage is certainly a legal concept in the judicial realm. The fact of the matter is, if a mortgage is satisfied, it is no longer valid. The fact that there may be an underlying obligation under a promissory note has nothing to do with the satisfaction of a mortgage. A mortgage can be satisfied and there can still be amounts remaining and due under the underlying note. So his argument to this court, which is not in his papers, it's not in the brief, and it's unsupported by the law, that the satisfaction of the mortgage should have constituted a discharge of the note obligation, is simply wrong. The satisfaction of a mortgage renders the mortgage ineffective. It's satisfied. You cannot enforce the mortgage, which is given as security for the note obligation. So that argument is simply wrong. Further, the court found that even if even if the deed lacked a date when Germinara executed it, there's no law that requires that the grantor's signature be executed on it doesn't have to be dated, particularly where you have an acknowledgement and a notarization, a jurat, which indicates when the grantor appeared before the notary, acknowledged his signature, and that jurat is signed. So the court found that that was an immaterial defect, and the fact that Mr. Adams put in the numeral 5 when it said April 2012, I guess, that had no effect. It was immaterial. And finally, that there was a handwritten notation on there stating confirmatory. The judge specifically found that that handwritten notation had no effect on whether the deed in lieu constituted an absolute conveyance of 77 Parker Street. Now, Mr. DiNardo seemed to argue that since a deed in lieu of foreclosure was given at a time when the loan was still in effect and not in default, that any subsequent deed that's given could not have cured that defect under the Levinson case, which found that essentially you can't give a deed in lieu of foreclosure in anticipation of a default under the loan. If we follow that to its logistical conclusion, that would mean that you could never rectify and you could never convey title to that property, and that's simply not true. Justice Karp found that the 2012 deed in lieu was executed by Germinara freely and willingly and intelligently after the loan had gone into default, knowing that he didn't have the means by which to satisfy the mortgage. And therefore, there's nothing in that deed in lieu of foreclosure that is invalid. It was found to be an absolute conveyance of the property, 77 Parker Street, from Germinara to PCM. So these issues were raised by Germinara at trial and they were adjudicated against him. Finally, the findings, rulings, and order state that neither PCM nor Bacchus acted in bad faith in taking title to 77 Parker Street by means of the 2012 deed in lieu, and that no conduct by them was unfair or deceptive. And so if there was no fraudulent conduct by them, it wasn't found to be a wrongful foreclosure and there wasn't any wrongful conduct, that topples the claims that Mr. Germinara asserted against Plum Island. In the Justice's memorandum of decision and order granting Plum Island's motion to dismiss, the court found that the Germinara failed to state a claim upon which relief can be granted, of course, finding that there was no actual controversy because the court had already rejected Germinara's assertions that the confirmatory deed was fraudulent and forged and the product of a wrongful foreclosure. And since it was ruled that the deed in lieu validly granted title to PCM, Plum Island, as its successor, held valid title to 77 Parker. So there was no existing controversy between the parties. The fact that Germinara disagrees with the court's findings and rulings in the underlying action does not simply create an actual controversy between the parties. We take the findings and rulings in order as conclusively resolving those issues. Second, the court ruled that the doctrine of issue preclusion barred Germinara from relitigating the issues. And I've already gone through that. There was there was privity between Plum Island and PCM because Plum Island was the successor title holder to PCM, and therefore the issues concerning the validity of the deed in lieu were actually litigated and essential to the judgment and apply to Plum Island as well. Third, the Superior Court ruled that Germinara's complaint against Plum Island failed to allege any commercial transaction between the parties and that there was no underlying unfair conduct. Now, Mr. Germinara argues an incredibly strange, convoluted, fabricated, made-up connection between an entity called NPRO, which was a tenant of Mr. Germinara's at one point, and Plum Island. And what he says is that NPRO was a former tenant at 77 Parker Street. David Cowie, who was the former treasurer of NPRO, was interested in purchasing 77 Parker Street from Germinara, but Germinara wouldn't sell it to him for less than $1 million. And that Cowie is the signatory for Plum Island, and that somehow makes them affiliates. And of course, affiliate is a legal conclusion. It's a legal definition that requires some showing of interest and control between two parties. That's what makes them affiliates. Not that an officer from one company becomes an officer in another company. By way of an example, I'll give you something that's very obvious and preposterous. Lee Iacocca was the former president of Ford Motor Company, and some years later became president and chairman of Chrysler Corporation. Nobody thinks that Ford and Chrysler are affiliates. Obviously, they are competing automobile manufacturers. That one person is an officer in one company and later becomes an officer in another does not make those companies affiliates. That's not what shows control. So that is the sole argument for which they rely to say that there was a commercial transaction between the parties, a business connection. Finally, the court improperly, Germinara claims that the court dismissed his 93 complaint because Plum Island knowingly participated in a fraud. Once again, that fails because there was no underlying fraud. The court in the underlying transaction found there was no fraud, and one cannot knowingly provide assistance to another committing a fraud if no such fraud was ever committed. And in sum, the Superior Court correctly dismissed Mr. Germinara's complaint against Plum Island, and we ask that this court affirm that dismissal. Thank you.
Thank you. Thank you very much for your argument. Thank you both very much for your arguments. They were very helpful. The panel has no questions with respect to your argument, so we'll take it under advisement. We'll get an answer to you as soon as we possibly can. And in the meantime, we hope that you and your family stay safe and healthy during this health crisis.
Thank you very much.
Thank you.
And with that being our last case today, the